Hey there, everyone. Josh Crowfoot here, Crowfoot Law Firm in Chattanooga, Tennessee. We're here on day 18 of Commercial Real Estate 101, and today we're going to be talking about environmental reports. An environmental report is key to any buyer's inspection of a piece of commercial real estate prior to purchase. If you are purchasing a piece of property that is classified as industrial or even retail, this is something you want to consider, especially if you're acquiring something like a dry cleaners or a gas station or something that used to be a gas station or used to be a dry cleaners. If you're purchasing a piece of property that falls into that category, you definitely want to get an environmental report. The entry level environmental report is going to be called a phase one. They'll do some pretty basic borings, test for certain chemicals, and if they find something and it reaches a certain threshold, then the engineer that's responsible for generating that report will recommend a phase two, which is a lot more serious. Environmental issues can be very expensive to fix. They can have a lot of liability for the seller. So anytime you're dealing with an environmentally contaminated property, you want to know what you're getting into, and if you're going to buy it, you definitely want to hire counsel that is versed specifically with environmental issues. But in terms of negotiating the contract, if you're on the buyer side and you're buying a piece of commercial real estate, you want to make sure that the seller is not limiting your ability to do an inspection. You want to make sure that you don't have to ask the seller's consent to get a phase two if it becomes necessary. As buyer, it's pretty customary for you to indemnify the seller for any negligence or omissions or acts of somebody that you bring to the property to help you with your inspection. But you do want to make it clear that if your environmental engineer simply discovers something that is a problem with the property, that you are not on the hook for some sort of liability for merely finding a pre-existing condition. That's a pretty heavily negotiated item in any commercial real estate agreement. With that, I hope you learned something new.